And we are live.
Chief, we're live and ready to go whenever you're ready to call it to order.
All right. Good morning. Call to order this meeting of the Judicial Districts Board. The meeting being conducted remotely because of the pandemic, like so many other things these days, but is being live streamed on the Texas Courts YouTube page. So it's TX Courts, and then you can find the YouTube page. David, please call the roll.
Chief Justice Nathan Hack.
Here.
Presiding Judge Ray Wheelis.
Here.
Presiding Judge Olin Underwood. Presiding Judge Billy Ray Stubblefield.
Here.
Presiding Judge Sid Harrell.
Here.
Presiding Judge Missy Maderi. Presiding Judge Stephen Abels.
Here.
Presiding Judge Dean Rucker.
Here.
Presiding Judge David Evans.
Here.
Presiding Judge Ana Estevez.
Here.
Presiding Judge Alfonso Charles. Presiding Judge Susan Brown.
Here.
Presiding Judge Sharon Keller.
Here.
Chief Justice Phillips.
Here.
Tom Phillips, excuse me. Chief, you have a quorum.
All right. Well, we have two new members that everybody knows. Since our last meeting, Judge Estevez and Tom Phillips, whom everybody knows. So we welcome them to our meeting this morning, and we'll go ahead and move along. You had an opportunity to see the minutes of the May 25 meeting. Any comments or objections to those minutes being approved? If not, they'll be approved without objection. And we'll ask Minna to give us kind of an overview remind us of our board responsibilities. Minna?
Thank you, Chief. Because of the new members, although I'm certain that they are aware of their duties, we always like to start off with just a brief summary of the board's duties. As you all are aware, the Judicial Districts Board was created in the Constitution. It's the only judicial agency that I'm aware of that's subject to the Open Meetings Act. So we are actually having an open meeting pursuant to Chapter 551 of the Government Code. It was passed in November of '85, and then in September of '87, the legislature had passed the enabling legislation that incorporated the provisions of the Constitution and then provided some additional duties and responsibilities. This board has subpoena and investigatory powers, as well as their regular rulemaking authority. The primary purpose of this board is to reapportion the judicial districts of the state, and they can do that at any time in between sessions. They can investigate and make recommendations to the legislature, but your big lift comes after each census, not after the session immediately following the census, which is this coming one, but the following one. If the legislature doesn't act to do any kind of judicial reapportionment, then that next summer you're supposed to start a meeting and look into it and make recommendations by mid-August following that session. And then if the Judicial Districts Board doesn't take any action, then it gets kicked over to the Legislative Redistricting Board. In your meeting materials, I provided just a short little summary of the action that the board has taken after each decennial session since it's been created. In 1990 is the one time when I believe the board actually held hearings throughout the state and actually presented a formal plan to the legislature. It was not acted upon, but that was when the Judicial Districts Board, and it was their first time, they really put a lot of time and effort into it. following the 2000 census, during that second session after the census, the Senate Committee on Jurisprudence asked the Judicial Districts Board to come up with recommendations as to how to proceed with reapportionment in the following session. And basically what they concluded based on the information given to them by the Judicial Districts Board was that you basically have to start from scratch. It's not that easy to just start moving counties around. And then nothing was really done that session either, the following session. And then following the 2010 census, there again was no reapportionment, but there was a judicial courts omnibus bill where several courts were created and some were reapportioned and redistricted. And the board met after that and determined that really no further action was necessary other than moving Leon County from one judicial district to another. And the board went forward with that was the only recommendation, and they submitted a letter to the Secretary of State as required. And that's pretty much the history of the Judicial Districts Board in a nutshell. Oh, and the other thing, Chief, I also just want to add, I added in the materials, in '86, the board adopted some rules that haven't really been touched again since 1993. There were some amendments, but it really lists a lot of the information that's provided in Chapter 24 of the Government Code regarding things that the Judicial Districts Board should consider when they're trying to look at reapportioning. Sort of a, it's the things that you'd think of, population, case filings, disposition rates, what type of activity happens in the counties and things like that. But those are in your meeting materials as well if you'd like to look at them for future reference.
Thanks, Minna. Any questions, Minna, or comments? Then we'll go to the court caseload statistics and trends. Angela Garcia.
Good morning, everybody. Because of the pandemic and the crazy filings, the effect on the caseloads in the state, I've been asked to go over the 2019 filings, and you'll be familiar with this information from the Council of Presiding Judges meeting last December. So I'll tell you what the trends had been before the pandemic, and then go through how the pandemic has affected filings from March to October. So in your materials, there are the charts. Overall, the district court filings had been increasing since 2014, but leveled out in 2019. But dispositions have not kept pace, with the clearance rate averaging about 95%, leading to a 10% increase in pending caseload. In the county courts at law, filings had been decreasing since 2011, but were increasing in 2018 and 2019 due to debt cases. Overall, the clearance rate had been under 100% since 2017, averaging about 97%, leading to a 10% increase in pending caseload. Filings in the constitutional county courts have been declining, as have dispositions, and pending cases have gone down proportionally. On page 2 of the charts, while the caseload in the district courts increased 10% overall over the last 5 years, juvenile cases have consistently declined, and family and civil cases related to criminal matters declined in 2019. But over the last 5 years, there had been significant growth in the civil cases, mostly due to debt. In 2019, family cases continued to make up the largest share of the court's caseload, but criminal had increased by 1 percentage point and civil by 3. The proportions of the family case categories remained basically unchanged, with nearly 40% of the caseload comprised of Title 4D matters. The percentages for criminal case categories remained stable, with drug offenses counting for 1/3 of the caseload. On the civil side, tort cases rose by 1 percentage point to the top, and debt cases increased 3 percentage points to become the second largest civil case category. In the county courts at law over the last 5 years, criminal cases have been consistently declining, down 10% over the last 5 years. And there has also been enormous civil case growth and steady growth in probate, mental health, and family cases. In 2019, criminal cases continued to make up the largest share of the court's caseload, but civil was increasing again due to the debt cases. DWI rose to the second most common category, and drug cases fell to a third. Debt cases rose 48% to 48% of the total caseload in 2018 and 56% of the civil caseload in 2019. In the county courts at law, the filings have declined 15% over the last 5 years, but civil cases due again to debt have grown 18%. The probate and criminal case categories remain stable, while debt cases rose from 30% of caseload in 2018 to 40% in 2019. Statewide, the number of new family cases filed declined in 2019, and there were decreases in 3/4 of the case categories that we track. Compared to 5 years ago, the greatest percentage increases have occurred in protective order cases, not associated with a divorce, and those are up 25%. There had been significant increases in child protection cases, but there was a 7% decline in 2019. The National Center for State Courts has noted that this is a national trend, and speculation is that it's due to the Families First Act to keep cases out of court. 4D matters have also been a significant area of growth, but there was a 7% decline in 2019. Divorce cases continued to decline, particularly in cases where children were involved. And SAPSers not involving a divorce declined significantly. As I've said, debt cases have been surging over the last 5 years, up 88% overall. A large share of these cases end up being dismissed or result in a default judgment. In almost half of cases were dismissed by the plaintiff or for want of prosecution, and nearly 30% resulted in a default judgment. Another area of significant continuous increases are motor vehicle tort cases. Since 2012, the number of cases filed has nearly doubled. Misdemeanor cases have fallen by a third since the peak in 2007 to the lowest level since 1991. Felony cases, however, reached an all-time high in 2019. And drugs and DWI account for a large share of both caseloads. The number of felony drug possession cases filed increased to a new peak in 2019. After hitting a peak in 2017, the number of new misdemeanor drug cases filed decreased slightly, then declined in 2019 due to the hemp law. After 9 years of decline, the number of misdemeanor cases, DWI cases, increased over the last 2 years, and so have the felony DWI. Even during that pandemic, we're seeing the family violence cases increasing. They've been increasing since 2014 on the felony side and since 2017 on the misdemeanor side. Since the peak in 2007, the number of juvenile cases filed has fallen 50% to the lowest level since 1993. And while filings declined in most case categories for juvenile, significant increases are occurring in robbery, auto theft, and felony drug charges. The number of probate and mental health cases has been relatively stable, while new guardianship cases have declined slightly. When broken out by administrative judicial regions, district court caseloads increased in 6 regions. Statutory county court caseloads increased in 8 regions, and county court caseloads increased in 2. This also shows the clearance rates for each region. And the final slide is the age of cases disposed for each region for the different case categories. And now we come to the effects of the pandemic. So we looked at March through October and compared it to last year. Overall, filings in the district and county courts have declined by almost a quarter from last year. Juvenile cases have declined by more than 40%, but probate and mental health cases have only declined by 6 to 8%. So not really affecting caseloads there. Unfortunately, dispositions have declined 40 to 50% in the district and county courts in every category except civil, where there's only been a 28% decline. So overall, the clearance rates for the district and county courts is 75% compared to 96% last year. The clearance rate for felonies is 64%, 69% for misdemeanors, and 75% for family cases. So we have significantly growing backlogs in those areas. Civil's doing fairly well at 90% and juvenile at 94%. So overall, the pending cases have increased by 9%, but misdemeanors have increased by 17% and felonies by 23%. And that's all I have for you. Does anybody have any questions? You're muted, Chief.
Questions for Angela? Well, then thank you, Angela, for those always very interesting numbers. Wish the numbers would tell us why as well as what, but I guess that's what we're supposed to figure out. Now we'll turn to Jeff Sunakawa for the OCA's weighted caseload study. Jeff?
Good morning, everyone. Thanks for having me. So for those of you that are not familiar with the weighted caseload study, the weighted caseload study is a methodology in which we do a time study working with judges across the state to determine how much time they're spending on their cases and distinguish that by case type and hearing type. We use the data from this study to help determine the judicial need for courts. The last time this was done for Texas was in 2007. So the current data and methodology we have is about 13 years old. That study was primarily focused on our district courts. So from the 86th legislature, OCA was directed and appropriated to contract with the National Center for State Courts to update the weighted caseload study. That weighted caseload study process was scheduled to begin at the beginning of 2020, with the study commencing in April and a final report being delivered in December of this year. Obviously, with the pandemic occurring in March, that was not the right time to conduct any type of judicial weighted caseload study. So that project has been put on hold until 2021. We're still waiting on when the most appropriate time to study the time that judges are spending on hearings is going to be. Returning to courtrooms is going to be an important part of that. So we continue to wait to see when the best time to do that is. In the updated study, we have expanded it from district courts to also include our county courts at law, our children's courts, and probate courts. So we should have quite a bit of data when those reports are finally released. Although we did realize it's important to also capture the amount of time that judges are spending on cases and hearings in this pandemic time. You're all aware, and we've all heard that in some case types, there are a lot of efficiencies that are being found in conducting cases where you're having witnesses or just all the participants appearing virtually, so there's not delays of childcare or parking or those types of things. So there are some case types that are actually being disposed of far more efficiently. So we worked with the National Center for State Courts earlier this year to conduct a grant application to which we submitted to the State Justice Institute. The grant application was simply that we wanted to do a small time study of a small selection of courts across the state and do the same type of weighted caseload study, but in this virtual setting. We knew if we waited too long, we would lose the opportunity to actually gather information on how efficient cases are going in this virtual environment. We're pleased that actually just 2 days ago, we were notified that our grant application was approved. So I was able to let David know that good information. We have exactly 12 months from 2 days ago to conduct this mini weighted caseload study. The scope of the study is 6 jurisdictions across the state. So we'll be working to determine 6 jurisdictions anywhere from rural to urban to conduct a mini time study on virtual hearings. We hope to use that data to supplement our full in-person weighted caseload study that should be completed by the end of 2021. With those numbers, we should have more current and up-to-date data for courts to have when they request information on new judicial needs within their courts or establishing new courts. So unfortunately, everything from 2020 is now pushed off to 2021, but we're ready to start these time studies as soon as these in-person hearings allow us to. But in the meantime, we'll start doing a study on virtual hearings. And that is the status of our rated caseload study.
Questions of Jeffrey?
Chief, if I might,
Yes.
really quickly, just to make sure everybody's aware of why that weighted caseload study is important to the Judicial Districts Board's work. Basically, that is the information that we are able to use to quantify the need for judicial officers, how many judges we need to cover the caseload in each district or each county. So for instance, if we were to run the weighted caseload study numbers as of right now in, say, Collin County or Harris County or others, it would tell us exactly how many judges were needed to accomplish the number of cases that are being filed in that district or in that county. And then based upon that information, quantify where the judges need to be. And so one of the things that we expect, we've been using that information since 2007, and the legislature has almost or maybe exclusively used that information to determine when to create new district courts. But as you look to do your work, we think that information will be helpful, and certainly the updated information when it becomes available would be helpful to you in your work. So we're looking forward to getting that information, and we expect to have that for you by the time you need to take further action before as Minna pointed out, around the 2023 session.
Chief, can I make a comment?
Please.
I was talking to Judge Kent Sims, who presides over the Dallas Tax Court, just before we started our meeting. And he told me with virtual hearings now that he has a much larger percentage of pro se's that are showing up for the hearings in tax court. So Jeffrey, that's probably something you want to visit with, is Judge Sims.
Interesting.
We have about 19 judges currently. We have a judicial needs advisory committee, which is composed of about 19 judges across the state, as well as a couple of court administrators. But we can definitely confer with him on this virtual study.
The Title IV judges echo what Judge Wheelis say. The participation by I have to think of the jargon that's used in Title IV-D, but obligors and obligees. But anyway, mothers and fathers, it's just way up because they're able to still maintain their personal schedules and then come work and things like that, and then take off when their hearing is actually up. And so we have a report out of Wichita Falls that's pretty dramatic over a 12-county region, and the other district judges are echoing that same issue about pro se's participating virtually. Grace is.
We're having the same experience in child protection cases as well. Parents are participating much more actively than they have in the past.
I hope before the end of the year, our court will create a remote proceedings technology working group some judges and lawyers and others that we're going to try to assess all of these impacts and what's happening, and try to come to some recommendations on what we should try to keep and not let slip away once the pandemic eases, and what's not working, and we need to find out other solutions for or change again once we get more flexibility. But there's going to be a kind of a comprehensive effort to look at the whole use of technology in the justice system and try to identify what we've learned and what we're just sort of reacting against. And their reports due, I think, June or July. Well, then that brings us to the discussion of what plan we need to evaluate the need for reapportionment and the desirability, necessity of new districts, and what specifically what we want to begin to do to be ready for the 2023 session and anything in between. So we just open the floor to how we should proceed. David, you want to lead us off on that?
Sure. Thanks, Chief. Really what we were hoping to get from you all, number one, if there's anything that you want to do now, obviously we would want to know that. But the main thing that we as staff to the Judicial Districts Board wanted to know is what actions you would like for us to take in preparation for your work during the interim. As you saw in Minna's report earlier, after the 1990 census, there was a series of meetings that occurred in the winter and the spring during the year that you all had to take action. And so we were just thinking, this would be a great time to hear from you before we show up for that meeting in a couple of years and we don't have what you want. So, if obviously, things like the weighted caseload study that will be available to you, but are there other actions that you would like for us to take and meeting schedules and things like that you would like to do to kind of prepare for that 2023 timeframe?
Chief Justice Phillips.
Well, I've forgotten more than I ever knew about this subject, but my recollection from the 1990s effort was that there had not been comprehensive redistricting of the district court since the 1880s, which seemed like a long time. But when we got into it, there were some threshold questions that we just didn't start early enough to resolve. And one of them was, are you better off having a bunch of non-coterminous multi-county districts that are kind of a patchwork, like in East Texas? In fact, most of the rural area east of I-35, where one county may be in 3 different judicial districts, but each of the 3 has different boundaries. But you can find a judge, but there's no one judge that's really responsible for that county. Or are you better off, like at least in the 1990s, most of West Texas was, where there's just one judge, and you know who your judge is, and there's no escaping that responsibility. And obviously the bias is, I think for most people that appear in the courts, is going to be, we like it the way we have it. And if that's the case, that's fine. But if there's some kind of, obviously, no other state has these crazy things. Like Anderson County in the 1990s was in 4 different judicial districts, none of which looked like had the same boundaries as the other 3. I'd like some kind of systematic study, whether that's a poll of the lawyers who appear in these courts, or just asking the National Center about, should there be a presumption, a default, that this is what a district should look like, or do we just build on what we have? That's the first thing. And then the second thing is we have plenty of judges as the numbers go, compared to, our population. But there's not a lot of flexibility. And the legislature sets up, in the urban areas at any rate, the legislature says this court shall give preference to X, to civil cases. And then if all the civil cases are being mediated, it kind of takes an act of the legislature or a very strong local and regional presiding judge to tell the civil judge, hey, you don't have anything on your docket, why don't you go do some family law cases? So more flexibility there would probably mean the need to create fewer new judgeships, but is that within our scope or beyond our scope? And those are my only two thoughts.
I would just point out in answer to Chief Justice Phillips' comment that in 1990, Anderson County was in those various districts. Nothing has changed. Those East Texas districts are, they are complicated. I remember after the 2010 census, Judge Moore, presiding Judge Moore, who is now retired from this panel, and I sat together for a couple of days in a conference room trying to untangle some of that mess, and it's definitely very difficult. The other thing I just think that you all should remember as part of this, and it's something we can add to any study that we do for you, is when you redistrict the district courts, you also affect other offices. In particular, district attorneys are generally tied to judicial districts. So we'll need to keep that in mind as we do that. So it's interesting, some of the district attorney districts are even more unique in the way that they're written into statute as well. So
there were, at least 30 years ago, 5 different kinds of district attorneys, and sometimes combined, misdemeanor and felony combined. Some counties had 2 district attorneys. Kerr did, I know. So do we want to think about all that? And there's 2 other big overlaps. One is a whole lot of medium-sized counties don't want the expense of a district judge. So they want to be, at least in my day, it was Clayburgh County and Cass County were big enough and had caseload enough for a district judge. They didn't want, it's not the expense of the judicial salary that's largely, if part entirely borne by the state. It's the probation office and all the other things that go with a district judge. They wanted to be attached to another county. And how much do we defer to that and how much should we not? And then there's the whole area of county courts at law, some of which are virtually coterminous in their jurisdiction with district courts, and some have very small jurisdiction. And that can change at any time. How much do we want to take a long view of that, or do we look at a snapshot of, well, as it is now? Because, of course, many counties would rather have a county court at law. They love criminal county courts at law, was always my impression, because they were nearly always a profit center, and the judiciary as a whole is not a profit center. So the complexity of our system is way beyond the scope of this board, but I think before we're called into action, we ought to at least have some thoughts about how much we're going to suggest changes to that and how much we just deal with the realities on the ground. And this final thing I say, I promise, but in 1990, we had this major effort and hearings everywhere. And I did an elaborate plan, but of course I wasn't on the ground. So I had one district that there was no road between the 2 counties. You had to go 2 counties down and over and back up. So that wasn't a very practical suggestion. And by the end of it, all I wanted was to not have any judicial district in Texas that wasn't coterminous, because we did have one that had a few counties here and then 1 county over somewhere else. And I think we did solve that. So in 2000, I tried to do nothing, relying on the provision of the Constitution that the Legislative Districts Board had to act if the Judicial Districts Board didn't. But they took the position they didn't have to act. And of course, there is the question of if one new court is created or one boundary is changed, does that obviate the need of this board to meet or the need of the legislative board to do their thing if we don't? So there are just some unanswered questions in the whole area.
Well, maybe we should ask OCA to put together kind of a plan to look at some of these areas that Tom's asked about. And then we can, we don't have to meet, but we could revisit, just take a look at the proposal and see if we do need to meet, and begin to plot out what we're going to do so that when we get asked questions in the 2023 legislature, we'll at least be able to demonstrate that we plowed through this.
Chief, we can shoot for a goal to try to, have that information for you. I'm just sort of thinking time frame wise, maybe by late summer or early fall next year after session, to sort of see what changes may come out of the session with regard to new districts and things like that. And that would give you all, a pretty good runway for your work, and then maybe get that out to you and then see what you want to do from there. Hopefully by then we'll maybe start to at least have some of this weighted caseload information as well. Maybe by late fall next year, we can have that information available to you as well.
I may ask a question. Is it possible to get some preliminary figures from the census, sort of peek behind the curtain to see any major surprises on the offing?
We will be able to get that information. My understanding is that there's still question about when that census information will be delivered to the state. I think there's been discussions about that'll either be late spring or midsummer, somewhere in that time frame. So once we get that information, we can use that as well. We've traditionally looked at caseload numbers, but we can pull in population shifts as well as part of that information.
Tom.
I lied about not talking, but this is a question to the presiding judges. Is it a problem that some judicial districts are in more than one administrative region? I mean, is that never a problem or occasional, or is it something that we ought to be mindful of and either try to keep all the judicial districts in one region or suggest changes to the regional lines along with what we do? Just a thought.
My impression is that one or two sessions ago that was addressed.
Right.
Okay.
And it's pretty well been taken care of.
Yes.
I gained a county in order to eliminate a district that overlapped between Judge Underwood and myself.
See, David, things do change.
We worked on that when we redrew the lines and added a couple of administrative judicial regions. We tried our best I think every time we have an opportunity where there's a change to try to simplify this, because I think all of us recognize it's fairly complex. So when we can, we try to make them. Those changes were fairly easy to move one county in the regions from one region to another. There may be still some that overlap. I can't remember exactly, but I know we moved several around. I think Judge Rucker gained or lost a county or so, and a few of the others judges as well, just to try to eliminate the overlaps.
I think it happened when the bill that created 2 additional regions as well, Judge Phillips. There's now 11 instead of 9.
Judge Phillips, I lost a lot of counties in East Texas. So I'm just down to the metro area now.
And is that a good thing or bad?
It's a good thing. It works out well for me and Judge Charles also.
Good.
David, did I understand from what you said that the legislature's not going to have census data in time to redistrict?
So I think there's a question about that. There's, at least in the press that have been reported here in the state, the question is when that data will be made available to them. I think there's some concern about delay. I think there's optimism that maybe the legislature will get that by late spring, March, April timeframe. But there's also some reporting even in the last week that has said that might not be available to the state until July, the July timeframe. So I think there's still questions about when that will come. So we'll have to wait and see when that information gets to them.
And I'm drawing on memory here, but doesn't the legislature have to take a swing at it before it can go to the districting board?
Mena, you want to take sort of the who goes first in what order?
I mean, I think in theory, you could make a recommendation in between. If we had some work that we could present to them for their 2013 session, I think what happens is if they don't do anything, then you are supposed to meet and then address it that following summer.
And Mena, can you correct me? I think it's either the constitutional provision or the statutory provision says that the JDB can make a recommendation at any time.
Right.
They have to they just have to take action if the legislature does not act in the third year after the census. So I think, based upon my previous conversations with legislative members, they would appreciate the input of this board if you have ideas about how they might take action, even if that recommendation is no action. But whatever your recommendation is, I think they would appreciate it before next session, and then maybe they can go through their process of doing that during session and before you all have to take action. And as Mena pointed out, if you all don't, and I think Chief Justice Phillips brought this up about the 2000 time frame, if you all don't, then that shifts over to the Legislative Redistricting Board, which may or may not take action as well. I think they're obligated to take action if JDB doesn't, but I guess we'll see what that does if you don't.
But more broadly on state and federal legislative districts, does the legislature have to try to do something before it goes to the redistricting board or not?
I believe so. I'm not an expert in that area, but my understanding is, so what I've heard is if the census data is delayed to a point where they can't do legislative redistricting and congressional redistricting, that there would be special sessions called to address those issues before that would then go to the legislative redistricting board. I don't know the time frame under which that transitions from the legislature to the legislative redistricting board. That is certainly a duty of the legislative redistricting board if the legislature fails to act.
Right.
But there'll be a lot of pressure to get that done in time for the 2022 elections.
Right.
Yes. I assume that filing deadline of end of 2021 will be, a deadline looming over them of getting any action taken on the legislative and congressional side. The other thing I would just say to all of you, regional presiding judges in particular, but really anybody else listening into this, is it might be worth noting the way that new districts are created, and the way that the legislature has handled that in recent years is that if there is a desire or a thought that a county or a certain area needs a new district, then basically we work with those officials at the local level to run the weighted caseload numbers against their numbers to tell them what the numbers at least show. And then of course, there has to be a bill filed in the legislature to create a new district court. That requires certain steps to be taken at the local level because it's generally a local bill. So the commissioner's court has to take some action to post that and get feedback and things like that. There's generally a resolution passed by commissioners' courts. As Chief Justice Phillips pointed out, most of the cost is on the local level. So certainly that's an important step. And then what generally has happened in the last several sessions is that the chair of the Senate State Affairs Committee and the chair of the House Judiciary and Civil Jurisprudence Committee will file a omnibus bill and roll all of those new court bills that are justified by the numbers up into one bill, which then is a mega bill that moves along pretty swiftly through the session. So if counties out there are listening, or if you, regional presiding judge, know of counties where there's a desire for additional district courts, they really should be taking action now to prepare for that. I did read in the press last night that I think it was McLennan County has just passed something in the last day or so saying they need new additional courts. So if you all have courts out there that know of that, or if others are listening, that's really the process. But we're happy to help, OCA happy to help with trying to show them what the numbers show in preparation for that decision.
Chief Justice, the Article 3, Section 28 of the Constitution says 2 or 3 times that the legislature has to redistrict during its regular session. So if you don't get the numbers till July, I don't think any of us should comment on it because that's probably going to be your problem.
Other comments? Other discussion? Well, is there any public comment, David?
I'm just looking at the list, and Kelly, if you could verify for me, the way we authorize people to provide public comment was to log into the webinar to participate, and I show 0 people logged in to the webinar to participate. Kelly, can you confirm that?
Yes, that's confirmed. There are nobody.
The Chief, I believe we have no public comment.
Okay. Well, if there's no other business, then we can adjourn the meeting. It doesn't look as if there is. So this meeting of the board will then stand adjourned. Good to see everybody. Happy holidays. Stay safe. See you soon.
Thanks, Chief.
Thanks, Chief.
Bye,
Glad you're
Chief.
with us, Tom.
Bye, thank
Good to
you.
see you.
It's an honor to be
Christmas.
back.
Yes.
Well,
Glad to have you back, Chief Justice Phillips.
Thank
Yes.
you so much.
Good to see
Bye-bye.
everyone.
Merry Christmas. Happy New Year.
Merry Christmas.
Merry Christmas.
Merry Christmas.
Hey, David? Where'd
Hang
you
on
go?
1 second. 1 second. We're still, just 1 second.